Yes, how are you? Today we, as usual, we'll do our class for criminal procedure. Last time we had reached the level where we had discussed the trial process until conclusion of the process itself, where the prosecution and the defense counsels had done the submissions. So now it was upon the court to go back and write a judgment. So then today we look at judgment briefly, on the ingredients of judgment, how the court is supposed to write judgment. Thereafter, we'll then proceed and look at mitigation and sentencing, then look at appeals and then revision. Now, we'll start with judgment. Of course, I stated that when the court has gone back to, after conclusion of the trial, we'll go back and write the judgment, and it's expected that then the judgment has some kind of ingredients that must be followed so that it's delivered. And one of the ingredients, there are about 9 of them, and most of them, one of them is that the judgment itself should have the title, that is the name of the accused person. If it's Republic, it's Republic versus John Njuguna. And then, or maybe if there's more than one person who is accused, it becomes maybe John and 3 others. Then the judgment should also have the charges or the charge sheet. If it was maybe 1 count, then it should have 1 count. If it was 2 counts, it should have 2 counts, so on and so forth. And then the other ingredients is that the judgment should have the statement of issues. Because for any charge that is being tried, there must be issues. If probably it was a murder by maybe John, then it needs to state that one of the issues, whether probably John committed the offense of murder, and probably 2, what are the circumstances, so on and so forth. So then it also must have the summary of the arguments. And because as any litigation, the prosecution side must always have an argument that they presented to the court during trial. The defense counsel, if the accused person was represented, or if the accused person was in person, then must also have those arguments. Those arguments must also be put as part of the judgment. Now, similarly, the court should also have a holding of the court on each issue. As we've seen before, that the court then must have summary of issues, then there must be a decision on each issue. If there are 4 issues that the court had framed, then there must be a decision on each issue. And then after that, then there must be the court's reasoning. The court's reasoning on each issue must always follow in the judgment, and then there must be now summary, the statement of the decision based on the finding of each count. That is, if there are 4 counts, there are 5 counts, then there must be a statement whether the accused person is guilty on count 1, count 2, or acquitted on count 1, and found convicted on count 2. Yeah, then again, when the court is making a decision on the final analysis in the judgment, it must state either it can either acquit an accused person completely, that's discharge, full discharge, or it can either convict an accused person either on count 1 if the accused person was charged with 1 count, or more than 1 count if the accused person was charged with more than 1 count. Or if there are multiple charges, then the court might acquit accused person in 1 count and then convict in the other counts. That I think could be fine with the judgment. Briefly, we look at mitigation. Mitigation is a presentation of either evidence or certain factors that, or information that may mitigate or maybe assist in lessening on the sentence or reduce charges of an accused person. And of course, we can look at some few factors which can be mitigating. One of them is the degree of provocation. For example, in murder, if it is shown by the accused person that there was a degree of provocation to the extent that he had no choice or made him to commit the murder, then the murder itself might be reduced to manslaughter. And then secondly, the instances whereby an issue of mental illness may arise in the criminal culpability of an accused person. In such an instance, depending, if the accused person is able then to mitigate and say, as a result of the mental illness, then the charges or the sentence may reduced. Others include of maybe like if the accused person may plead guilty at the earliest, then the sentencing may be reduced. And then again, being a first offender, might also go a long way in assisting the accused person to have a lesser sentence. Then the conduct, of course, if an accused person shows that he or she is remorseful, then the sentence might also be lessened. Now, but again, remember that it's, you need to note that, yes, these guidelines are not exhaustive because there are also judicial discretion, which sometimes might consider other factors not mentioned for use to be in the as a mitigating factor in the decision. Now, we then move to sentencing because we know we have explained that the process, once you do judgment, then the accused person is either convicted. Of course, for acquittals, the person is set at liberty, meaning there won't be any post-judgment trial. But now, here, if an accused person is convicted, then now you go the whole process of now mitigation and then sentencing. Now, sentencing definitely are the penal consequences that then accused person will be able to be given. It is provided for in the criminal justice system, and objectives of sentencing ordinarily are 5 or more. But some of them to mention would be deterrence, like to deter an accused person so that they don't commit the offense again. Then to denunciation, whereby when you do a committal, then you are like denouncing to the society that such offense should not be committed because the consequences. Then the restorative justice, of course, the victim must be considered. It's purposely most of it to restore justice to the victim. And then again, there's also the community protection. It's good that the community is protected from criminals who then commit offenses. And then there's also retribution. It's important that the offender is punished for the crime that they have then committed. Now, the principles of sentencing, which of course in the courts, we have the sentencing guidelines of the judiciary, it must always be considered, and the court will need to look at uniformity, whereby sentences are supposed to be uniform in similar circumstances. Then we have transparency and accountability, whereby the sentences is imposed are supposed to be based on in the law, which is a statute already. Then now inclusivity, that's inclusiveness, is whereby it's supposed the sentencing should rely on the evidence that adduced by both the victim and then also the offender. Now, we then move to the types of sentencing in Kenya. We have the custodial and non-custodial in general. Custodial is when now you are incarcerated, you are in custody kept. Non-custodial are ones that then you would serve the sentence while outside. And generally, in respect to custodial sentences, when it comes to children in conflict with the law, ordinarily the purpose of the court for the youth offenders is to preserve their life and to rehabilitate them. Towards that extent, then children who are found to be in conflict with the law and given custodial sentences are supposed to be sent to education institutions or Boston institutions for purposes of rehabilitation. Now, custodial sentences mostly would be imprisonment and also death sentence for murder. But non-custodial vary. We have community service order under the Section 3 of the Community Service Order of 1998, which involves those people who have been sentenced for not more than 3 years. Then you also have probation under the Probation Offenders Act of 1981 at Section 5. An accused person may be put in probation or under probation. Then there's an aspect of compensation, especially if you look at Section 31 of the Penal Code, whereby the complainant may be compensated in lieu of the sentencing. Then fines, of course, the Act allows, the Criminal Procedure Code allows for fines as a way of, the Penal Code, sorry, allows for fines as a way of sentencing. Then you also have absolute and conditional discharge, whereby you might be discharged conditionally or you might be discharged absolutely without any condition. Now, ordinarily, you are told that we'll discharge you, but you make sure that you don't commit an offense within the next 12 months. If you look at Section 35 of the Community Service Order Act. And then we have restitution, that is Section 178 of the CPC, where now the person who then is the complainant can be restituted. Then we have instances of revocation of licenses, like environmental matters. If then you go against the Environmental Coordination and Management Act, then your license can be cancelled. Then we have instances of forfeiture, where now we deal with the issues of property. Then you can always forfeit your property. Now, of course, now we have done judgment, we have done mitigation, sentencing. Now, assuming that you have been sentenced and you are dissatisfied, if you're dissatisfied, you can either appeal or go for revision. But now let's look at appeals briefly. Now, the right of appeal is a constitutional right under Article 50, sub-Article 2, paragraph Q, and then Section 347(1) and 379(1) of the CPC, where if you are an accused person, intends to prefer an appeal. And procedurally, there are 3 levels of appeal. There's appeal from subordinate court to High Court, then from High Court to Court of Appeal, then from Court of Appeal to Supreme Court. Yeah, then of course, sometimes a person who is appealing or appellant might be interested to apply for bail pending appeal. So an appellant may apply for bail pending appeal, and the only ground for that would to ensure that at least there is the case has, or the appeal has high chances of success. And then also an appellant may also apply for stay of execution of the sentence of the trial court pursuant to sections 356 and 357 of the CPC. Now, briefly, we look at appeals from the subordinate courts to the High Court. If the appeal from the subordinate court to the High Court is ordinarily by way of a petition or appeal, which must be done within 14 days. And of course, it's normally on matters of facts and law. And of course, if you look at that is now Section 347, subsection 2 of the CPC. And then the court requires that the appellate court will basically, the role is to reevaluate the evidence of the subordinate courts. And I've said that it must be filed within 14 days. And the procedure at the High Court when appeals is filed is that it is supposed to be by way of a petition under Section 351 of the CPC. And then 350 subsection 2, it must be signed by the appellant or the advocate if it's presented. And then it is supposed to set out the particulars of the matter constituting the grounds of appeal, and then it must indicate the address in which the documents must be served. And then it also provides that a decision of the Court of Appeal itself during hearing, the court might either decide to have it set aside the conviction, or it can also enhance sentence, or the court can also quash the decision. Now, in the procedure itself, for the appeal itself, the court may also summarily reject the appeal under Section 352(2) of the CPC if the appeal is brought on ground that the conviction was against the weight of evidence and that the sentence is excessive. And this, of course, ordinarily under Section 352, subsection 1, must be done sparingly. You look at the case of Abdi Wali Hassan versus Republic, criminal appeal number 49 of 2015. Now, the court may also grant, the circumstance under which the court may grant appeals itself, the weight of evidence does not support the conviction. If the court makes a finding that the weight of the evidence does not itself support a conviction, meaning that the trial itself, the prosecution was not able to produce sufficient evidence, and also that if there's communication from the ODPP in writing that the office does not support the conviction under 352 subsection A of the CPC. Now, the instances whereby during the trial certain evidence was not available It allows then the Court of Appeal then to admit additional documents, and of course it's a discretion of the court, so long as appellant is able then to demonstrate that at the point of the trial then that evidence was not valuable. Then we briefly look at appeals from the High Court to Appeal, and of course the appeal from the High Court to the Court of Appeal only relies on the matters of law purely, not a factual matter, and of course it should be filed within 14 days, and it must be by way of a notice of appeal to the High Court, to the Court of Appeal, High Court, and then the procedure. At this point, the power of the appellate court itself can determine the matter finally. Then it can also remand the case, meaning that it can take the case back to the lower court or the initial trial court for a trial. It can also take additional evidence. It can also order for a new trial, and that would be the powers of the appellate court. Now, procedure at the Court of Appeal is purely under the Court of Appeal rules, and Rule 59 of the appeal, it's on the issue of lodging the notice of appeal, which must be done from the 14 days I've stated. And once that notice is lodged, then the registrar of the High Court, pursuant to Rule 62, Sub-Rule 2 of the rules, then is supposed to prepare a record of appeal, which then will contain the proceedings. It must therefore contain the judgment or order appealed against. It must therefore contain the notes of the High Court judge, and then the exhibits, if the exhibit. And then once that is done, then within 14 days of preparing, then the appellant then must therefore lodge the appeal itself, the memorandum of appeal to the registrar, and then thereafter setting the grounds, of course, of the appeal, and then thereafter the matter then will be set down for hearing. And during hearing, the hearing is governed by Section 7, Section 71, Rule 71, Sub-Rule 1 of the Court of Appeal rules, and whereby parties must both attend, and during the hearing, parties then must receive themselves to the grounds set out in the memorandum of appeal. Yes, the last part would be now, it comes to appeal to the Supreme Court. Then it must involve a matter respect to the interpretation of the application of the Constitution, and it must be certified that the matter is of great public importance, and certification as referred by the Constitution and with leave as used in Superior Court Act are the same legal meaning. This case of Lawrence, Ndutu, and 6,000 others versus Kenya, Brothers and another, petition number 3 of 2012. And according to Article 163, Sub-Article 4B, as read together with Section 16, Subsection 2A of the Supreme Court Act, the application of leave to the appeal to the Court of Appeal must be made to the Court of Appeal or the Supreme Court. Now we look at our last topic for today, which is now revision, and the court then, High Court then, or the Superior Court then, has power to revise records of an inferior court pursuant to Section 362 of the CPC, which then is to call and examine the record of any criminal proceedings before any subordinate court, so that it satisfies itself as to the correctness, legality, propriety of any finding, sentence, or order recorded or passed, and as to the regularity of any proceedings in the subordinate court. Then the High Court then, while exercising this power, then pursuant to Section 364, it can also exercise the powers now under Section 354, 357, 358 in respect of an appellate court, whereby it can either remit the matter back to the lower court, or order for a new trial, or take additional evidence, or increase the sentence, or reduce the sentence, quash the sentence, alter. And of course, then it can also reverse or alter as stated. And then while doing this, the court then may not impose a punishment greater than the one that is imposed by the subordinate courts, that is section 364, subsection 3 of the CPC, and then it can't also convert an acquittal to a conviction pursuant to section 364, subsection 4 of the CPC. And that would end our day, ladies and gentlemen, and enjoy. Thank you.
These televised lectures supplement our robust online learning going on our MKU online platform. You can view more on our televised lectures via our online platform. We are in a digital era, and Mount Kenya University knows this. The following are the steps to follow so as to complete your online application. Download the application form from the website www.mku.ac.ke. Attach copies of your academic certificates and ID. Pay the application fees via M-Pesa pay bill number 270988. Your ID is the account number. 2,000 shillings is the charge for a postgraduate. You can also deposit in the bank accounts provided on the website. Then email all the above to apply@mku.ac.ke.